On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution,
I will deal with the aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various reliefs arising from the partial success of the consolidated petitions. Our jurisdiction to issue such reliefs is firmly anchored in Article 23 of the Constitution, which empowers the court to grant appropriate remedies for the enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 2, Sub-Article 4. Orders of compensation and orders of judicial review. The courts have over time provided guidance on the considerations applicable in granting constitutional reliefs. In affirming that a court is not confined to the remedies expressly enumerated under Article 23, the Court of Appeal in Total Kenya Limited versus Kenya Revenue Authority 2013 reported, held that even where specific reliefs are expressly provided, a court is not precluded from issuing any other orders under the inherent jurisdiction, as long as such orders are necessary to ensure that justice is done between the parties. In the same vein, the High Court in Simeon Kioko Kitheka and 18 others versus County Government of Machakos and others, held that Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where the constitutionality of legislation is challenged. Similarly, in Republic versus Ex parte, Chudasama, the court emphasized that courts retains inherent jurisdiction to fashion appropriate remedies to secure the ends of justice. Speaking to the nature of appropriate reliefs, the Constitutional Court of South Africa in Force versus Minister of Safety and Security said as follows, and I quote, appropriate relief will in essence be relief that is required to protect and enforce the Constitution. Depending on the circumstances of each particular case, the relief may be a declaration of rights, an interdiction, an interdict, a mandamus, or such other relief as may be required to ensure that the rights enshrined in the Constitution are protected and enforced. If it is necessary to do so, the courts may even have to fashion new remedies to secure the protection and enforcement of these all-important rights, end of quote. Regarding declarations and damages for constitutional violations, the Court of Appeal in Gitobo, Imanyara, and others versus Attorney General, report in 2016, emphasized that constitutional remedies, the court may award compensation. The comparable common law measures of damages will often be a useful guide in assessing the amount of this compensation. But this measure is no more than a guide because the award of compensation under Section 14 is discretionary, and moreover, the violation of the constitutional right will not always be conterminous with the cause of action at law. An award of compensation will go some distance towards vindicating the infringed constitutional right. However, how far it goes will depend on the circumstances, but in principle, it will not suffice. It may not suffice. In fact, that the right is violated was a constitutional right adds an extra dimension to the wrong. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, emphasize the public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and to deter further breaches.